In the words of Kofi Annan, the former Secretary General of the United Nations, he said, and I quote, "We are here because we know literacy is the key to unlocking the cage of human misery, the key to delivering the potentials of every human being, and the key to opening up a future of freedom and hope. We at Know Your Right Nigeria believe that via this platform, that hope can be translated into reality." Without much ado, I welcome you to another edition of Know Your Right Nigeria. I am Ntamegbe and I will be your anchor for the show. The goal of this program is to educate and provide you with information about human rights in Nigeria, so you're empowered to make the right social, cultural, and political decisions. On the show, there are different segments. Now we've got a new segment where we get to bring you the latest human rights news. Then we go out there to the streets, interview Nigerians about those pressing human rights issues they are faced with daily in their lives, bring in a human rights professional to talk us through these challenges in a structured manner, of course, and how to overcome them. In our usual tradition, we will begin the show by going over to our news desk, which will provide us with an opportunity to serve you with the latest human rights news. Then we'll go out there to the streets, listen to the conversations our team had with Nigerians about what we will be talking about later during the show. Our guest is right here with me, and he will be officially introduced to the show, and it's expected that he will respond to the questions we have concerning our topic for the week. Now, I can tell you for free that this show will provide you with an illuminating experience as more light will be shed on those areas of the law that have oftentimes been misunderstood, and you don't want to miss any part of it, so don't go anywhere. We'll be right back after this break.
This is Human Rights News on Know Your Rights Nigeria. First, the headlines. Man kills Katsina motorcycle operator, steals bike. Man assaults mother, commits suicide in Adamawa. Kano court remands lady for insulting mother. Court remands suspect who removed trader's heart. And now the news in full. Man kills Katsina motorcycle operator, steals bike. A 46-year-old man, Isiya Inusa, has admitted to killing a commercial motorcyclist, Al-Hassan Usani, over his inability to pay the 100 naira fare charged by the deceased. Inusa told journalists at the headquarters of Katsina State Police Command on Thursday that he killed his victim with a knife following a disagreement over the fare. He said, "Yes, I slaughtered him with my knife. I asked him to take me to Kabuki village from Kankara. He demanded 100 naira fare, but I did not tell him I could not afford it. On our way, I drew out my knife and slaughtered him. The police later arrested me while riding on the motorcycle," Inusa said in Hausa. Police sources said the incident happened on Tuesday along Kankara Kabuki Road. It was, however, learned that Inusa tricked his victim into taking him to Kabuki village with the aim of snatching his motorcycle. It was along the way that Inusa drew out a knife and slaughtered the motorcyclist, after which he dumped his body along the road. The blood stains on his clothes and the motorcycle gave him away to our vigilant officers, who promptly arrested him before his case was transferred to the headquarters, a source said. Man assaults mother, commits suicide in Adamawa. Tragedy struck in Yola, the capital of Adamawa State, recently when a 23-year-old man, Fidelis Musa, committed suicide after an argument with his mother. Musa's lifeless body was found dangling in his room in Jimeta, Yola, after a misunderstanding with his mother, which left her with a sprained wrist. According to family members, the deceased, afraid that his mother may curse him following their brawl, decided to take his life. Neighbors of the deceased said it was known for abnormal behavior, which his cousin, who identified herself as Susie, attributed to hard drugs addiction. Susie said her cousin might have taken his life following the altercation with the mother, afraid that she might curse him. She said it was the first time the deceased beat his mother, adding that his misconduct may not be unconnected to substance abuse. An eyewitness, Innocent Henry, said on the day Musa committed suicide, he attacked his mother, causing her to sprain her wrist and leg. The man was restless throughout that day. He fought everybody that came to their house. He wounded his mother by breaking her left hand. Already, we have taken the woman to a native doctor for treatment, he explained. Henry further said that before his death, Musa's family members were thinking of leaving the house for him over his erratic behavior. An uncle to the deceased, Ali Hassan, said he had behaved strangely on the day of his death. I am the uncle to the deceased. He has been making negative confessions, especially a day to the ill-fated day. He told everyone that someone among his family members will die the next day. He was a generator mechanic apprentice. We noticed the strange behavior without the premonition that he was going to commit suicide, he said. Kano court remands lady for insulting mother. Kano Senior Magistrate Court, presided over by Ajia Umar Sani Kumawa, on Thursday in Kano ordered a 20-year-old lady, Umi Abdullahi, to be remanded in prison custody over an allegedly insulting her biological mother. The charge sheet, read in an open court, said Umi hurled verbal insults on her mother. It further noted that Umi, on March 4, 2017, at Badawa quarters committed the acts of criminal intimidation, intentional insult, mischief, and attempt to commit an offense. Police prosecutor Sergeant Ibrahim Sanyawa said the offenses committed were in contrast to the provisions of Section 397, Section 327, and Section 95 of the Penal Code law. According to him, the accused lady committed further offense by attempting to stab her biological brother with a knife, saying the brother had earlier stopped her from stealing a goat and a hand-push truck belonging to the family. Umi proceeded to her mother's bedroom and knowingly set all the wares in the house on fire, the court was told. The accused pleaded with the court for leniency, noting that she regretted her actions and pledged that she would not repeat the acts. The prosecution thereafter applied for a summary trial of the accused. Senior Magistrate Umar Kurawa ordered the accused to be remanded in prison custody and adjourned till May 16 for summary trial. Court remands suspects who removed traders' hearts. 3 persons accused of removing the heart of a produce trader for ritual purpose were on Wednesday remanded in custody after they were arraigned before an Iyagonku Chief Magistrate's Court in Ibadan, Oyo State. The charge, with number MI 563C17, stated that the men, Tunde Jimo 37, Gbenga Babalade 40, and Olatunji Hamed 42, were charged with alleged conspiracy, murder, armed robbery, unlawful possession of firearms and accessory after the fact. The accused were said to have conspired to kill a trader, Akintoye Oyeyemi, and remove his heart on a cashew plantation, thinking that he had 10 million naira on him. After killing their victim, the suspects were said to have found 100,000 naira on him, which they also took away. The police prosecutor, Sunday Ogunremi, told the court that by their acts, the accused committed murder. He also told the court that he had 1 quarter-size gun with 2 live ammunition in their possession, adding that they also intentionally concealed vital information. Ogunremi said the offenses contravened sections 324, 319, 1 subsection 2A and B, 3 subsection 1 and 322 subsection 9 of Criminal Code Cap 38, Volume 2, Laws of Oyo State. Counsel to the third accused, Mr. Segun Popola, asked for his bail, but the presiding chief magistrate, Mrs. Abiola Richard, denied the request, saying the offense was punishable with life imprisonment upon conviction. He adjourned the case till while ordering the accused to be remanded in the Agodi prison, Ibadan. That was human rights news from the news desk on Know Your Rights Nigeria. I am Jalala Adishino.
You're welcome back from the news desk, and our topic for the week is your right to fair hearing in Nigeria. Again, our topic for the week is your right to fair hearing in Nigeria. Before I bring on our guests, Know Your Right Nigeria was on the street. Let's listen to what Nigerians are saying.
But I think it's a complete negative, if you ask me, because I've seen some examples where I visited the maximum prison in Kirikiri, where I spoke to some of the inmates, and I was made to understand that they've been there for quite a number of time. Some of them have spent close to 2 years, some of them are there for like 6 months, and each time they're supposed to go for a trial in the court, they kept on telling them that the lawyer probably not around, the judge maybe not around, or something is always wrong for me. I think here in this country, here in this part of the world, trials are not done within the time frame, and which makes so many people spend a number of time, a lot of time in the prison for the for something they've not done, perhaps, or some of them must have spent even more than the number of time they're supposed to spend if the trial had been done eventually. So for me, I think it's negative. Well, it's a two-way thing. First and foremost, yes, you have the right to your own counsel, but some of us, most people cannot afford, lawyers of their own choice, and we know how a big deal that is in this country. And if you are supposed to rely on what government will provide for you, you might not be able to get a fair defense from that lawyer. So for me, it's a big deal here in this country because so for you to afford the cost of a lawyer is very, very expensive. And so for me, I would say that most people going through trials don't get what they actually want because of the circumstances around it. I don't think that is applicable here in this country because a lot of you can have an institution, for so to speak, where crimes are on the high, and you see students committing rape, cultism, but it stays within the house. The max they will do is take them to a nearby police station, hand them over, and let the government take off from there. But when that process is being done, you eventually see those students back in the four walls of the school because proper, how do I put it, proper judgment or proper trial is not being done. So for me, I think that schools are not empowered to, to undergo or to proceed in their own, unique or let me say, should I say unique? Their own independent, execution of law. So for me, I don't know if it's allowed in our constitution, but if it is, I think schools also have the right to do so. But it has to be done legally under the constitution of Nigeria. That's very dicey, I think, because if the offense, if you commit an offense, there should be, a judgment under the law. But like we know here in Nigeria, if you commit murder, there is a certain, judgment to that. It depends on what kind of offense you have done and how the judge deem it fit. Probably because there is always a twist to every crime here committed in Nigeria. But I would say that Nigerian law, we are still at the nursery level. You cannot really, be satisfied with whatever reaction or whatever judgment has been passed because a lot of people are in prison for what they have not done. A lot of people are being prosecuted for even offense they didn't know anything about. So for me, I feel that all of this needs to be put under review. A lot of judges are just there doing nothing, and I still ask a lot of questions. What are judges doing? That when you go to maximum prison out there, you see a lot of inmates, like I already said, I've been there, and I felt so sorry for them because a lot of people are there wallowing away and spending most of their lives there for offense they have not done or not been tried. I think for a trial to be done, you need to try every offender under a certain period of time because there's no reason why somebody should be there for a long time and eventually some of them didn't do anything wrong. So for me, most of them come out as a bad. The influence of them spending a lot of time there will affect them in their life, and you can never regain whatever lost time you have spent in that place. Well, here in Nigeria, I think it should be possible because if I'm supposed to look at some examples or some of the things I've seen outside of this country, I've seen somebody being tried and possibly the community are not satisfied with the statement or with the judgment of the judge, and then some set of people or some group of people can still go there and tell them that we want you to to do this trial again. But I think in Nigeria it should also be done because a lot of people influence the judgment of some judges, probably financially or because of their social status. But I feel that if we are allowed to also have that kind of process here where some set of people can say, okay, this judgment we're not satisfied with it, they go back to the court of law and tell them that the person should be retried again. I think it should be allowed here in Nigeria, but if it is not, I think our law is not complete. Well, to a large extent, I think I do. But do we stand a chance to fight for our right in this country? There's a difference between for us to know our right, and there is a difference between for us to be able to, fight for our rights. So for me, I know my right, but can I come out publicly and fight for my rights? That is in quotes.
By the way, one of the important things that can change your life is to know your rights.
Nigerians must learn to know their basic rights and defend such rights.
Know your rights, Nigeria. Nigerians actually deserve to know their rights.
Women's rights are to be protected.
Harassment from policemen would be limited once all Nigerians know their rights.
All child rights should be protected.
Rights now my property. So therefore, you can't dash me my property. Human rights, now my property.
You're welcome back. That was Know Your Rights Nigeria on the Streets, and our topic for the week is your right to fair hearing in Nigeria. To enlighten us on this topic is the former Dean, Faculty of Law, the University of Lagos, and also one of the leading legal practitioners in Nigeria, Professor Oyelowo Oyewo. It's so nice to have you.
Thank you very much.
How are you doing today?
I'm fine.
And we'll cut straight to the question. So, would you want to please tell me what is the scope to your right to fair hearing here in Nigeria?
Right to fair hearing in Nigeria is a right that is constitutionally guaranteed in Section 36 of the 1999 Constitution as amended. It's a right that has both substantive and procedural aspects. And it's a right that has civil and criminal application. Okay. So in terms of scope, it relates to any determination that's going to affect the civil rights and obligation of a person, okay, whether in a civil administrative hearing, which we call administrative adjudication, okay, which is also known as due process in other jurisdictions. And then we have the procedural aspect of it with respect to the need to observe certain, attributes in any proceedings whatsoever, okay, that relates to a person. And that's what will determine whether or not the process was fair to the person or the process was not fair. And if it doesn't meet the standard of fair hearing, then the whole process will not stand. Apart from the 1999 Constitution, we also have it in the African Charter Act, particularly Article 7, which provides for this act. But the provisions in the 1999 Constitution are quite detailed, and it also takes cognizance of the development of this right from the common law perspective of the principles of natural justice, which is also divided into two, under the Latin maxim, nemo judex in causa sua, and audiotarum partem. Audiotarum partem simply means hear the other side. Okay. Nemo judex in causa sua means, nobody should be a judge in his own cause.
Yes, because I'm going to ask you to, explain this further.
Basically, the two aspects of the hearing, the audiotarum partem, that is the hearing process, looks at the process. Okay. The nemo judex looks at the body that is making the decision. So in the nemo judex, we are looking at the composition. Is the composition biased? The decision to be made, is anybody interested in it? And we say that it is not only real bias. We talk about the likelihood of bias. Okay. And there is what you call the reasonable man's test in the whole process, that if a reasonable man observes the whole proceedings, will he say that the person who was brought before this body has been fairly dealt with? One, in terms of the composition, and two, in terms of the whole proceedings. So it's quite, involving.
Yeah. Because I was going to, there's so many things you actually talked about here, but I just want you to describe what it meant by standard of fair hearing. What did you mean by that?
Yes, the standard of fair hearing which a body must meet is determined by law. Okay. So, for instance,
by law, you mean entrenched in the Constitution.
It's entrenched in the Constitution. So, it's entrenched in the Constitution, but it's developed under common law. So, you have the principles of natural justice. Okay. So, the natural justice, and historically, it actually started in the Garden of Eden, where God was going to make a determination on Adam and Eve. He gave them
spiritual.
No. I'm just being historical.
Okay.
I'm being historical as to because it's natural justice, and natural justice normally derived from a particular school that traces things to beliefs, and God gave Adam and Eve a fair hearing. So if God set that standard, we also the least we can do is to give people a hearing. But it has been reduced to the Constitution. So in Section 36, you have sections dealing with civil proceedings, that is what we call administrative adjudication. And then you have criminal proceedings, the standard that must be met. And each one of them, you need to meet them. If you don't meet them, the whole proceedings will be declared null and void, irrespective of what the person has done.
Brilliant. You talked about the other side. I know I heard you say the other side. You said that a couple of times. So now, what does that mean, especially when it comes to the ex parte court ruling, where the person whose ruling is against, is not aware of such a matter concerning him, and the person is looking to go back into the court? I mean, how does this? Yes, how does this operate?
Right. Now, ex parte.
Because I know you talked about the other side.
Hearing the other side is a fundamental requirement of fair hearing. Now, if you look at the provisions of Section 36, subsections 2 and 3, it deals with ex parte proceedings, in the sense that ex parte proceedings are a stage in the proceedings.
But before you go on further, would you want to explain what's ex parte proceedings?
Okay, ex parte ex parte is where you have two parties before a court in a proceeding, but one person bringing an application before a court that, look, because of certain urgent, circumstances, compelling reasons, the court must make an order. It's normally orders of preservation. For instance, somebody wants to demolish, the government wants to demolish somebody's house. Okay. So the person will rush to court and say, make an order to stop them and bring them before the court. And that's where the hearing the other side is. Normally an ex parte order is made to the next hearing date, when the court will ask both parties to come, by which time you will have served a motion or notice to the other person that, look, this is what I want the court to determine. So they will also respond. So there is always hearing the other side, even in ex parte proceedings. Because from ex parte, you go to motion or notice, which is that other side you obtain the order against, you have to serve them and come. And if there is no justification for the order, the court will expunge the order, because there is the need to always hear the other side.
Okay, so there is a need to always hear the other side. So, on the principle that you can't be a judge in your own cause, of course, and I agree that such a complainant should not be the one to decide the fate of the accused person. So now, what if someone kills a man? Unfortunately, the person who's standing trial is before the deceased wife as a judge.
Well, basically, that brings about the issue of competence of a tribunal to make a determination. That's looking at who is making the decision.
Yes, but I haven't finished asking my question. Okay, so now my question really is, must the judge who the wife is being the deceased, must the person excuse herself from, the court proceedings, or is it okay to continue?
If you start from the reasonable man's test, that answer is clear. In the eyes of a reasonable man, if you have such relationship that is so compelling that even irrespective of yourself, in the eye of a reasonable man, it will be deemed to have colored your judgment, then you should recuse yourself. So in this instance now, there is when we say that there is bias can be on the basis of relationship, it can be on interest, it can be on association. Once that bias is there, there is the likelihood, you see, is the likelihood of it. So it could be that, look, there is a likelihood that because you are related to the deceased, either by marriage or by blood or by whatever means, it will not be fair to bring such a person before you. So it's clear that fair hearing will not, allow that. The rules of fair hearing will not allow that.
Okay. So when we say a trial must be within a reasonable time in the Constitution, how come some accused persons are still languishing in prison right now? And I mean, there are so many people out there without trials, and some have overstayed the number of years they should have spent behind the bars. I mean, how does this play out?
Well, one thing you have to, understand is that the Constitution, in terms of fair hearing, also deals with personal liberty of people. So the moment a person is arrested, on that side of the requirement of the law, the person must be brought before a court within a reasonable time. Now, the Constitution to fair hearing, the constitutional provision of fair hearing, also, guarantees the person a hearing in a reasonable time.
Yes, you said this reasonable time like 2 or 3 times.
What is reasonable time? Yes, reasonable time, one, in terms of arrest, for instance, would mean that the person must be brought before a court of competent jurisdiction within a period of 48 hours. Within 48 hours.
That's 2 days.
Yeah, so that's the maximum until the court, makes an order. Now, when the person is charged before the court for a criminal case, particularly, once the person is charged, you now find out that the person must have an opportunity to answer to the charge, whether he's guilty or not. His plea must be taken. Once his plea is taken, the process starts. The process now is dependent not only on the prosecutor, it's dependent also on the defendant counsel. So you find out that delays may not necessarily be at the instance of prosecutors alone. Delays may be at the instance of defendant counsel. Delay may also be at the instance of investigators, and that's why we have the practice of holding charge, where a person is taken before a court that doesn't have competent jurisdiction, like a magistrate court, in the case of murder, and then the person is kept in a maximum security awaiting trial, pending the investigation. So basically, that is frowned on by the Constitution. Nobody should be brought before a court that doesn't have jurisdiction. But that practice is still on in order to safeguard that a person who has committed a heinous crime is not left without proper, order. So in order to fulfill constitutional requirement, the person is taken before a court of no competent jurisdiction, held pending when he's taken before a high court that will have the competent jurisdiction. Now, after the person is brought before a court, reasonable time is when the process will go through the trial, and at the conclusion of trial, first the prosecution must have his case, and then of course the defense must have his case. Now, this varies. It may take a year, it may take 2 years, it may take 3 years. However, once the trial is concluded, the judge must give his decision or his judgment within the constitutionally stipulated time after the conclusion of the trial. If it doesn't, then the whole proceedings will be declared, in violation of constitutional provision. So reasonable time varies. That's why the word reasonable. That is on the circumstances. Is the trial moving forward from day to day? It's strange. It would be strange if, for instance, a trial starts and 1 year down the line, nothing. 2 years down the line, nothing. Then that person should go to court to, have that particular proceedings, terminated for not having diligent prosecution of the matter. So it lies in the hands of the defendant counsel. If there is excessive delay to bring the appropriate motion to terminate the proceedings, and that is often done.
So if I understand what you just said, I mean, what you're saying is this reasonable time, I mean, what we just talked about, they are relative.
Yeah.
I mean, they're actually subject to each case, because I was actually hoping we could establish, a specific time frame per case, because just as you talked about 48 hours immediately after arrest. So what you're trying to say is that there's no specific window of time for, most cases.
No constitutionally specified time for handling a case, in the provisions of our law. But they are relative. But don't forget that apart from the Constitution, we have the criminal proceedings, criminal procedure code, and the civil procedure, rules that will regulate. So, for instance, in the civil proceedings now, there's been substantial reform, so that case management, what we are talking about is case management. Yeah, case management. So the judges are given, more authority to be involved in civil proceedings. But the same has not been done for criminal proceedings. So in case management, for instance, the court can say that, look, this matter should go for arbitration. So a matter that will have taken 7 years, it goes to arbitration, and and then it takes etc. Now Lagos State, for instance, has what you call the multi-door system, and the multi-door system brings mediation, conciliation, and arbitration. So you go there, and very interesting. I've been before this, and they order us, the lawyers, out. So they order you out, and the parties sit down, and they resolve the matter, which lawyers may take forever in determining, and then they bring the lawyers after they have resolved and announce the thing to them, and it becomes the judgment of the court. So there are reforms in the area of civil procedure, but I think there needs to be a correlative reform in criminal procedure. Yes. And now we have the Administration of Criminal Justice Act that has brought the reform in the criminal procedure. Okay. So it's just that it's in the process of implementation. So by and large, the issue of delays will be, ameliorated, and before we know it, the issue will still be issue of police investigation.
Anyway, I mean, with that, we all should be expectant, like for shorter time cycles.
Yes, for criminal proceedings too.
Okay, that's very interesting. So now, tell me, what does adequate time and facilities to prepare and present defense by an accused person standing trial mean? But for instance, in a criminal procedure, you need to give the accused the charge, and then they need to have the proof of evidence, and then the accused needs to have time to meet with his lawyers. The accused also needs time to respond to the charge. So if this is not done, then it's violative. You can't bring the accused to the court today and then you want to convict him. That's wrong. Okay. So, I mean, everything, whatever it is, whatever material, whatever resources the accused needs must be aware of.
Yeah, even in civil matters. You can't use, there are so many cases, we don't want to get into the decisions and be technical. We want to keep it simple. If you bring an evidence that was never made known to the person and you want to use it, it's an abuse. We always joke about it. In teaching, we say that.
Would you want to please hold your thoughts? We'll be right back after the short break. Okay.
Yes, you can now access all your rights simplified in English and Pidgin languages on Know Your Rights Nigeria mobile app. My rights at the police station, documents you need before buying a property, rights of women and child, among others. You can now access with a push of buttons in your palm. Ask our team of lawyers questions on human rights issues bothering you. Report emergency abuse of your rights to agencies like the Nigerian Police Complaint Unit, Consumer Protection Council, National Human Rights Commission, LASMA, among others, through Know Your Rights Nigeria app. Assess institutions and organizations with legal aid and enforce your rights. How? Download and install Know Your Rights Nigeria app through your Android Google Play Store free of charge. Non-Android phone users can also be empowered by visiting www.knowyourrightsnigeria.com. Know Your Rights Nigeria is a project of Constitutional Rights Awareness and Liberty Initiative, Crowley, with support from the U.S. Consulate General, Lagos.
By the way, One of the important things that can change your life is to know your rights.
Nigerians must learn to know their basic rights and defend such rights.
Know your rights, Nigeria. Nigerians actually deserve to know their rights.
Women's rights are to be protected.
Harassment from policemen would be limited once all Nigerians know their rights.
All child rights should be protected.
Rights now my property. So therefore, you can dash me my property. Human rights now my property.
You're welcome back, and you're still tuned to Know Your Rights Nigeria, and this week we are talking about your right to fair hearing in Nigeria. So we were talking about the adequate time and facilities required to prepare a defense case, and I know you talked about proof of evidence. Would you want to please?
Yes, I was going to say that, look, in this area we always say that there's no guerrilla warfare. It's conventional. Okay. Once the court sees that you are hiding something or you want to use some hidden, it's not allowed. That's why we call it fair hearing. Okay. Whatever evidence, whatever testimony that you want to use must be, if it is not brought before the accused person or even in a civil proceedings, administrative education, So fair hearing means it's conventional warfare. You fire, I see it coming, I deploy my, anti-missiles, and fair enough, if at the end of the day there's sufficient evidence, then the person is convicted.
You're actually making this sound like war zone, like the missiles. And okay, thank you very much for that. So our constitution says an accused person has access to counsel of his choice. So for instance, if I want you to if I want you on my case and I don't have enough money on me, since you are my choice, does that automatically mean you are my counsel?
Well, the law doesn't say a counsel of your wish. there's a wish, there's a difference between wish and your choice. Your choice should be within the context of what you can afford. Okay. If you can't afford the person, then it can't be your choice. Unless, of course, somebody can afford the person for you. The only people who get to enjoy that are those who are very clear that they can't afford a legal counsel. So we have the legal aid. In Lagos State, we have Office of Public Defender. We have, support for such people who will be provided with legal aid. But as respect the choice of having the best counsel, a good case that is normally used is the case of, Chief Oyelowo, when he wanted a foreigner to defend him. Yes, and it was held that he couldn't have it because the counsel of his choice must be a choice that can present himself with court without any hindrance. So if he needs visa, immigration, and all that to be done, he should pick another person.
Okay, so are you saying, saying this differently, it's a function of your...
It's a function of reality, that you can afford the person. And the person, even if you can't afford the person will make himself available. Because there are some, you can take a case on pro bono. I could make myself available to you on pro bono. On pro bono. Yeah, that is without taking any fee. So it's a practice for really outstanding lawyers to also make, just like it's a practice for medical geniuses to provide their services without charging. So also some lawyers. So if you are lucky and you want, and I have the time, I could make myself available at no cost. But if not, then you have to make do with who you can actually afford. Okay.
And the Constitution, if the Constitution presumes an accused person innocent until court decides otherwise, how come suspects are usually paraded as criminals on TV screens right here in Nigeria?
The police, in doing their jobs, will take pictures of accused persons, for their documentary purposes.
This is part of the procedure.
That's
this
part
is the
of
process.
Yeah, that's part of police procedure.
Okay.
But televising such people as criminals is what flies at the edge of whether or not their constitutional right has not been abridged. And the response that has always been given is that we don't run a jury system. We don't run a jury system. We run a system with judges. So basically, the judges, because of their legal training, are not as prone to be biased by televised, broadcast because of their legal training. But by and large, I think it flies in the face of human rights, violation to present somebody with all the evidence of guns and all that. And in some instances, civil society believe that what if the person is innocent? And the way they just round up people, and you are rounded up with armed robbers, and then they present you with gun. Even when you are set free, it's in the minds of people that you are suspect for armed robbery. So to that extent, that practice should not be encouraged.
Yeah, because it really is on the rise here in this in this part of the here within our climes. That's actually on the rise. Now, let's talk about trial before proper court. We say, for instance, can a student in a university be charged for the commission of a crime of rape, for instance, and be proved guilty before disciplinary committee or investigating panel, or does it have to be taken to a court or a tribunal?
Now, disciplinary bodies deal with misconduct. They don't deal with crimes because they do not have the competence to handle crimes, because criminal matters are to be brought before court of competent jurisdiction. And you also find out that there are established expertise, both in terms of investigation and prosecution, that deals with crimes that go before a court of law. And then the court, the highest court in the case of Saidu Gaba against University of Maiduguri, has held that where a criminal matter is involved, the balance of proof is beyond reasonable doubt. The balance of proof in a disciplinary body is, probability. So you can't take a higher level of proof and and then when the person goes before the court, if he's convicted, he will go straight to jail. He's not going to go and miss his studentship because he's committed a crime. So criminal matters are to be treated before courts of competent jurisdiction, while it's only disciplinary matters that are taken before disciplinary body.
Very enlightening. And on right to be tried for an offense known to law, is it possible in Nigeria that a matter will be brought to court without the offense and punishment clearly stipulated under a written law?
Under Section 36, particularly subsection 12, it's a requirement that a person be brought to court only for an offense or any matter that is clearly stated before the law, with the offense, with the punishment, so that the person will know. Where a person commits a crime, he hasn't committed, where a person does something that was not a crime at the time of doing it, a subsequent law cannot have retrospective effect to cover it, and that is also covered by Section 4. The legislature is incompetent in Nigeria to make retroactive laws. So either way you look at it in terms of the offense or the punishment, you cannot trace back at the time when somebody did the act. And the only times we've had that had been under military rule. The only other issue that people have talked about is Sharia. For instance, Sharia law is taken from Quran and the rest of it. But the way the people in those regions have argued is that they have looked at the laws of the Constitution, and they have set up courts to deal with it, and the courts to deal with it have been given the powers to look at Sharia offenses. So which means that they've done it like subsidiary legislation, and the Constitution allows for both substantive and subsidiary legislation. But another school of thought still believes that if you are taking your offenses from books and stuff like that, then it's violative of the Constitution. But this has not been ruled upon by our courts.
So now we understand that the Constitution provides for the right to be tried in public. Now we have cases of secret trials in Nigeria for the sake of national security, public peace. I mean, the list goes on and on and on. Is that an excuse? I mean, is that excuse not contrary to the provisions made available in the Constitution?
It's not. The Constitution qualifies the right to public trial with these grounds of security, grounds of public health, public peace, And even when you have juveniles, and if the court considers that in the balance of the whole proceedings, it's not in the interest of justice, that's the constitutional provision, so it's allowed. Yeah.
It is common that a panel is always set up to look at misconduct, at places of work, such panels at times recommend that the accused be sacked. Consequently, those indicted go to court and obtain a court judgment, And does that mean that most administrative panels in Nigeria don't follow the principles of fair hearing, or professionals are not always in charge of such panels? What exactly?
Well, it's a bit of everything. You have to look at it from the perspective of the fact that, considering the volume of administrative adjudication, the percentage that goes to court and succeed is not even that much. Because the system of administrative adjudication in Nigeria is massive. If you just look at the kinds of administrative institutions that we have, both in terms of ministries, both in terms of autonomic bodies, both in terms of professional bodies, and it's quite massive. However, where an administrative adjudicative process is violative of the provisions of the Constitution with respect to fair hearing, of course, you can sack the person 10 times. It will be sent back. And we have cases that have established that. What this means is that any administrative adjudicative body that ignores the provisions of the Constitution will always have its administrative adjudicative process declared null and void. This is even apart from the fact that we have a special court that deals with such matters relating to labor. That's the National Industrial Court. It's very, very functional. It's one of the newest and robust courts that is protecting employees from abuse of powers by employers wherever it's found. Yeah.
All right. So, can someone be tried over an act he committed? I mean, because we talked about it. When we talked about getting someone for something in retrospective mood. So, can someone be tried over an act he committed but wasn't a crime at the time of commission, but suddenly he made a crime following the law that's a week after?
That's the point you are making. That's retroactive legislation. Either retroactive or retrospective legislation, it's not allowed under Nigerian Constitution, both in terms of Section 36 and in terms of Section 4.
Be simple. We could actually move on from that. So, can someone acquitted by law be tried again for the same offense?
You see, this is a very technical area of the law. There's the principle of what you call ultra vires acquit and ultra vires convict. What it means in essence is that if you enter a plea that this charge you are charging me, I have gone through a trial and I've been acquitted. Now it will be looked at, is the new charge either smaller or could be subsumed in the charge for which you have been acquitted. If the answer is yes, for instance, if somebody in the same transaction was charged for murder, he goes to court and is set free. You can't bring a smaller charge for manslaughter after it's been set, because you should have charged the smaller in the bigger. So for that instance, that person's plea of having been previously convicted will stand. The same thing goes to ultra vires convicts. If the person says, I've been convicted and I've served my term for this lesser offense, then it must be that you are bringing a fresh charge from a new transaction before you can overcome the constitutional defense of ultra vires convict or ultra vires acquit.
Okay. So does an accused person have a right to the copy of the judgment after trial? Is that?
Yeah, the person is constitutionally guaranteed. And if I may go back to that, plea, there's also what we call the principle of double jeopardy. When somebody has gone through a trial, to bring another trial will be a double jeopardy, and that's constitutionally guaranteed that nobody should stand a trial that would constitute double jeopardy. Now, to go to the right to the proceedings, the judgment, it's a constitutionally guaranteed right that the person must be given the opportunity of having access to the judgment not more than 7 days after the judgment has been given. But in Nigeria, that sometimes can be a challenge, because electricity, courts could be on vacation, you know. So, but basically, the person's constitutional rights will be violated if he's not given access to the judgment and you want to execute that judgment.
And we all know that everybody has a right to appeal a matter up to the Supreme Court right here in Nigeria. We had of one Nasiru Bello case where the accused person was quickly executed while his appeal was pending. What's your take on this?
Well, to do a pun on words, Nasiru Bello case was a nasty case in the sense that constitutionally nobody should be denied of his constitutional right to life, even if there is a pending judgment, as long as there is a pending appeal. And in that case, all you have to do is to read that case. The courts did not spare the government that did that. That was the government of Oyo State. And the court, you know, really deprecated that particular action. And we pray that no government of the state of Nigeria will repeat Nasiru, you know, Bello's. It's a at the worst, what's your hurry to convict the person? There are so many condemned convicts who are waiting, you know, execution. So why is there interest in that particular person to be exterminated? So the law cannot be used that once there's a judgment of a high court, you go, no, that's not our constitution requires that the person's right to appeal to the highest court, which is the Supreme Court, be exhausted. At which time then he also has a right to prerogative of mercy under the Constitution. So he can still appeal to the governor to commute his death sentence to life, and then after life to be given the prerogative of mercy. So if that is truncated, it's violative of his right to life.
Just before you go, have you got any advice for Nigerians? I mean, if you do, what final words would you want to leave Nigerians with watching the show, watching Know Your Rights Nigeria?
Well, my first advice is to the government to make the Constitution accessible to Nigerians, particularly in their language. The official document can be English, but it would be nice if my people in my village can read it in their vernacular language. It may not be the official document in which we'll prove cases in court, but it would be nice if, as far as possible, the Constitution is made, you know, accessible to people in their language. Because if you teach people in their language, they relate more. It ceases to be a foreign document. So, as a person who is passionate about constitutional rights, I want, you know, people to know it. And I can tell you, I had the wonderful response when I appeared on the television radio to explain rights in vernacular. That's when I knew that, look, even these concepts, they exist. For instance, if you talk about, you know, natural justice, this audio authoritarian pattern, the translation of it in Yoruba is very simple. It just says, Agbo Shika Lomboje Nikodajo. So if you relate, if a person can relate to that, it becomes something that breathes life as part of their day-to-day. Not that it's only when they translate the thing. So what happens when there's no English-speaking person around? Or when they go into the police station and nobody understands their language? And that's how we have miscarriage of justice. Then the second something is for the Nigerian Bar Association. We need to be more involved in the life of our people. More and more, people have ceased to be interested in the life of other people. So people don't do pro bono like before. People don't do activities, you know, except government does it. I think we are losing the essence of the profession when we only wait for government. I think the association can do more. They are doing, but we can always do more. And then to the level of the ordinary person.
Oh yes, because we talk about the everyday Nigerian watching
the everyday Nigerian, you know, must always be proactive. How do you become proactive? You know, ignorance is very expensive. So whatever you do, get to know the rights that is given to you. We always have children in the house. Let them read the Constitution to you. Know what is it we are talking about. The taste of the pudding is in the eating. This knowledge is acquired by reading. If you read, you become as knowledgeable as me. Thank you very much.
Thank you very much. It was such a pleasure having you.
It's a pleasure here.
Tell us, Professor Oyewo, we'll be right back.
Yes, so my people, you fit get all your rights for simple English and pidgin language on top Know Your Rights Nigeria app. Bam! As them lawyers, if you get any wahala, any gbege, any kasala when they disturb you on human rights matter, then they the background. You fit report the human rights matter to our government like Nigerian Police Complaints Unit, Consumer Protection Council, National Human Rights Commission, LASMA 2, then they the level. Just enter Know Your Rights Nigeria app. If then they abuse your right and you can't need organization or people we go help you. Na free oh yeah, kia. Download your own Know Your Rights Nigeria app for your Android phone Play Store. Na free oh. But if you not get Android phone, no shaking. Carry waka enter www.knowyourrightsnigeria.com. Know Your Rights Nigeria. Now the project of Constitutional Rights Awareness and Liberty Initiative Crowley. Now US Consulate Lagos supporter.
You're still tuned to Know Your Right Nigeria. Now, if you've got questions or inquiries regarding your rights in Nigeria, please feel free to forward them to any of our social network platforms whose addresses have been displayed on your screen, and our legal team will do their best to respond to you on the show. You can also catch us on YouTube on www.youtube.com/Know Your Right Nigeria. And for all you Android phone users, please feel free to download and install the Know Your Right Nigeria app from the Google Play Store. Now, this app helps simplify your rights enforcement in Nigeria in both Pidgin and English languages. I encourage you to get this app because it will provide you with up-to-date and accurate information on your rights. This is where we will be drawing the curtains on the show. I hope you had a wonderful time listening to us. Until same time next week when I come your way again, I am Ntame saying thank you for watching and have a productive week. Goodbye.